You think you're just running your business or managing your rental property, and then one day, unfortunately, you're served. And in California, if your assets are not protected before that moment, the other side can freeze your bank accounts, place a lien on your property, and dig through your financial records. I'm Ali Talai, an asset protection attorney here in California, and I help business owners and professionals shield their home saving account and investments before lawsuits ever hit the table. This video breaks down what really happens once you're sued in California and how smart planning can keep a judgment from touching the assets that matter most. Because once the complaint is filed, it is too late to move things around. Let's talk about how does a lawsuit start in California. Let's get straight into it. You're living your life or running your business, and suddenly you get a knock on the door or a letter in the mail. You have been served. In California, most lawsuits start with something called a complaint. That is just the written document where someone claims you did something wrong and you owe them some sort of money or you have to fix something. It might be a tenant suing you for an injury at your rental property, a business partner with a grudge, or even a neighbor upset about a fence line. Once you get served, though, that's when the clock starts ticking. In California, you usually have 30 days to respond in writing. If you ignore this, you almost always lose automatically. This is called a default. But once you respond, the lawsuit officially kicks off. Now, as an asset protection attorney, I have seen plenty of people panic at this stage. The first thing they ask is, can they take my house, my business? Can they take my bank accounts? And the answer is it depends on what you own, how you own it, and critically, what you did before that lawsuit arrived. That's where asset protection comes in, but more on that soon. Assuming you respond, now both sides get to dig for information. This is called discovery. In California, discovery means each side can ask for documents, written answers, and even force you to sit for a deposition. That is basically an interview under oath with a court reporter usually there writing down everything you say. Why does this matter for asset protection planning, you may ask? And that is because this is when the other side starts to look for your assets. If they think you have deep pockets, they get more aggressive. If they find nothing or it's all safely protected, you have a lot more leverage at that point. After discovery, most lawsuits in California do not go to trial. You will be pushed into mediation, which is a process where both parties get to sit together. There is a third party neutral, tries to see how things could be worked out. Usually judges don't want to see cases on their docket, so they will force or encourage mediation. If you cannot settle the case, then it is off to trial at that point. Trials in California can take months or even years to reach, and it's mostly years versus months. They're expensive, unpredictable, and stressful. And here's the thing, even if you win, you might spend a fortune on legal fees. Let's talk about what happens if you lose at the trial. The court can issue a judgment against you. That means someone has a legal right to collect money or property from you. This is where asset protection, if you set one up already, becomes your lifeboat. Once a judgment is entered, creditors shift to collection mode. They can garnish your wages, freeze your bank accounts, and record a lien against your property. But there are limits, and California law offers certain exemptions to protect essential assets if you plan correctly. Let's start with your home. California's Homestead Exemption protects a portion of the equity in your primary residence from most judgment creditors. As of January 1st, 2025, the exemption adjusts each year for inflation and ranges from $361,113 to $722,151, depending on the county's median home price. In Los Angeles County, homeowners qualify for the maximum protection, roughly about $722,000. So if your home is worth, let's say, $900,000 and you owe $200,000 on the mortgage that you have on the property, your equity is $700,000. That is fully covered under the current exemption, meaning a creditor can't force a sale to satisfy a judgment. But any equity above that amount remains exposed, and the protection only applies to your primary residence, not rental property, vacation homes, or any other property that you have. Now, let's talk about retirement account, another area where people often misunderstand California law. Employer-sponsored plans like 401ks are well protected under the federal law, the ERISA federal law. Creditors generally cannot touch them. IRAs and Roth IRAs are only partially protected. Under California's Civil Procedure Code, IRA funds are exempt only to the extent the court finds they are reasonably necessary for your support or that of your dependents. That is a judgment call, literally. A judge considers your total assets, income, age, health, and expected retirement needs. For example, let's say you're a Los Angeles business owner with $500,000 IRA and $1 million in other assets. A court might decide that only $200,000 of your IRA is reasonably necessary for your retirement, leaving the other $300,000 in this IRA, in this example, exposed and available for the creditor. So while 401ks are nearly bulletproof, IRAs in California are not guaranteed safe. Their protection depends on your broader financial picture. Finally, let's talk about your real estate and business ownership. If you own rental properties, investment properties, holding them through LLCs or limited partnerships can isolate liability. Each property should have its own entity, so a lawsuit involving one property does not threaten the rest of the assets. That is the power of planning. You cannot stop someone from suing you, but you can control how far their judgment can reach. The key is timing. Asset protection only works if you set it up before there is a problem on the horizon. If you wait until you're staring down a lawsuit, your option shrinks dramatically. So my advice is simple. The best time to protect your assets is long before any legal trouble shows up. Once you're in the middle of a lawsuit, most asset protection doors are completely closed. Common traps for California residents to avoid. I cannot leave out this part. In my years of practice, I've seen several common mistakes that put Californians at risk. Here are a few of them. Mixing personal and business bank account. This is called commingling, and if you do it, courts can ignore your LLC and go straight for your personal assets. Next one, forgetting to update ownership records. If you set up an LLC or a trust, but you never actually transfer your property into it, it is useless. Double check the deeds and the title of your assets to make sure they are properly placed into the entity or into the trust. Relying only on insurance. Insurance is great, but policies have limits and loopholes. Use it as the frontline defense, not your entire plan. Delaying until trouble appears. The law does not protect last-minute scrambles, so set up your asset protection planning and layers before you need them. DIY legal work? I get it. Legal help costs money, but one wrong form or skipped step can undo everything. You gotta make sure you have professional help when you're dealing with significant assets or complex situations, and you really want to make sure you have a proper asset protection planning in place. So now you have seen how the lawsuit process really unfolds in California from the moment you are served to what happens if you lose, and how proactive asset protection planning can keep your home, business, and investment safe. The key takeaway here is that you cannot wait until there is a problem. True protection is about structure, building layers that give you control, leverage, and peace of mind long before a lawsuit ever starts. But asset protection is just one part of the bigger picture. If you want to know how to structure your estate plan the right way and avoid the mistakes that can undo everything you have built, don't miss my next video. The truth about California living trusts, what to include in these trusts and what not to include in them. We will go over what really belongs inside of your living trust, what you should not put in there, and how to keep your family out of court while protecting everything you've worked for. I look forward to seeing you in the next video.